Well, anyway, we're going to kind of diverge a little bit, and we also have Warhamster joining us as well today, because we are going to. This was a show that we were going to do on Warhamster's channel, but that got kind of pushed back, and then we tried to reschedule it, and it just didn't work. So today we're gonna, because we promised it last week, now we're gonna do it for real this week. So Warhamster, welcome. This was really more your kind of idea. So I may just kind of pass the lead over to you, just let you kind of drive a little bit today.
Yeah, it makes sense. What we're doing tonight is Supreme Court Scorecard based on the recent decisions, and it's not whether we like the outcome or not. We're looking at it from the original intent of the Constitution standpoint. The couple questions we'll be asking is, well, is this any of the Supreme Court's damn business in the first place? Do they look to original intent, or was it outcome and politically determinative? And so it's a little bit different than how most people are going to judge the Supreme Court. But Doug and I have done this for the last couple of years, and it's been a fantastic exercise. You can find SCOTUS scoreboard or scorecard episodes on my Rumble channel at Warhamster on Rumble for the last couple of years, and it's been fun. So we're just going to keep the same format we did before, and what I'll do is basically I'll lay out. There's about 10 cases we want to look at, and if we can get to them all, I'll lay out basically the background of the case, what the majority ruled, what the dissent ruled, and Ron and Doug will pipe in any damn time they want, and we'll make it a discussion. After, we can't spend too much time on each case, but at the end, we'll give them a letter grade, A through F. And you'll be surprised that we're going to agree most of the time, but there'll be some dissents on our panel as well. So
I got, just I don't know what order you have in terms of going down, where you want to start, if it's order of importance, if it's like just how they were ruled and when they were ruled. But I was looking through the birthright citizenship case, and I came to some points where I was a little bit conflicted, a little bit almost. And some of the things that because I was discussing with AI, obviously, and I was fighting for what I believe is right, subject to the jurisdiction of, et cetera, et cetera, et cetera. But anyway, if that's the first piece you want to talk about, then I'm gonna reserve that until we get to the point where you want to talk about it.
Throw up the screen share that I just put up there, and I'll show you the order. All right, there's 10 cases there. The one we absolutely have to get to these bottom two: Watson versus RNC and Louisiana versus Calais. So if we're running late, I'll skip over a couple of the less important ones, but we're going to go pretty much in this order. And the first one you guys have not heard of, and that's Partain versus Florida. And there's a reason for that, because it's not a Supreme Court case yet, but it's going to set the trend for our whole discussion. So shall I jump in?
Fire away.
All right, I'm going to stop this screen share, and I'm going to have another one here in a second.
Now, I've actually heard of the case, but go ahead.
Well, it just was in the news the last couple of days.
Yeah.
So this is Partain versus Florida Board of Governors. And the 11th Circuit just made a ruling on this. And the question is, can Florida enforce its law prohibiting public university professors from promoting certain views on race and sex under the First Amendment? Most of these are DEI type of things. These professors are teaching stuff like the legacy, slavery, white privilege, anti-racism. Well, Florida's gone out there and said, you can't teach that in our schools.
I remember this. This was a big fight several years back when they were
it started in 2022.
Yeah.
So a group of the Florida educators, which are a bunch of DEI professors and some of their students, they filed a lawsuit in August 2022. And of course, the NAACP and the ACLU joined in that. And the judge issues, of course they did. And the judge issues a partial injunction. And so that's been going back and forth for a while. But we got a decision on that yesterday, I think it was. And I think this is going to Supreme Court. I just wanted to read this decision because it'll set the tone for what we're going to talk about. So if you can throw me back up there again, Ron.
Yeah, don't remove it from the stage. Just leave it up.
Well, I'm going to a different tab, so I have to. Okay. So this is from Twitter. And SCOTUS Wire says in a 2-1 vote, the 11th Circuit ruled that Florida cannot enforce its law prohibiting public university professors from promoting certain views on race and sex under the First Amendment. So if I pull this up, U.S. Court of Appeals, and I just want to read this opinion to you. And I'm going to try to zoom it in so that people can see it a little better. Is that going to be big enough? That's as big as I can get it.
Nah, not really, but go ahead.
It's short. It says Congress shall make no law abridging the freedom of speech. U.S. Constitution Amendment 1. The First Amendment incorporated against the states. Gosh, I can barely read that.
Hey, can you send it to me? Send me the link.
Yep, you got it right now. Text coming right now. It's just so small. My eyes are just in pain. There you go, Ron. Well, Doug, while I'm doing that,
are you sending it via text?
I don't know if you saw me shaking my head or not.
Yeah, I didn't. Because I was trying to read.
I was shaking my head as I was reading it a little bit ahead of you. And yeah.
Warhamster, did you send it via text or did you send it via private message behind the scenes?
I sent it via text.
I don't have it yet.
Okay, then I'll put it in private chat.
All right, so
I think it just came in. Here it is.
So here we go. We go the first words, the first 5 words of the First Amendment. Congress shall make no law. Who's that addressing? The United States Congress. Read the 10th Amendment. What does the 10th Amendment say? You know exactly where I'm going. This is really, I'm laying this out for the audience. 10th Amendment, powers not delegated to the United States by the Constitution or prohibited by it to the states or reserved to the states respectively. So then our question is this type of issue given to the federal government as an authority when it comes to? No, in fact, the First Amendment tells them they cannot make law. Is it prohibited to the states? No. Therefore, it's up to the states to decide what to do on these issues. Now, the problem is the incorporation doctrine. And they were, and Judge Grant was very, very careful to make sure he mentioned the incorporation doctrine. He understood what the defense against the ruling would be, and immediately in the very first sentence puts the First Amendment incorporated against the states in 1868. So what the incorporation doctrine means from their point of view is that any rights, anything in the Bill of Rights, including the 9th Amendment, so all rights can be, the federal government is the enforcer. So therefore, the Bill of Rights applies in the same way against the states as it does the federal government. And then they also misinterpret the Bill of Rights because they don't believe that it's there to secure our rights. They believe it's there to ensure that government protects, guarantees, and promotes and defines rights. And because of the alleged incorporation doctrine, they can do it to the states as well. That's what they're saying. And it is about as unconstitutional from an originalist point of view as you can get.
Yeah, every single one of the founding fathers did not believe the Bill of Rights applied to the states. Period. They would never have ratified
the preamble. Read the preamble to the Bill of Rights. It lays it out.
They would never have ratified the Constitution or the Bill of Rights had they thought that you're going to put a bunch of federal powers to have a negative on state powers. There's a reason every single state has its own Bill of Rights. This applies to the First Amendment, 2nd, 3rd, 4th, 5th, 6th, 7th, and 8th, 9th, and 10th address it. This changed not after the 14th Amendment, but not by the crafters of the 14th Amendment. And the Supreme Court cases decided, called the slaughterhouse cases, they upheld that the Bill of Rights did not apply to the states. It didn't start being applied to the states until 20th century activists, progressive judges decided, hey, here's a way to give the government more power.
And let me add something here real quick, because I get people all the time. The 14th Amendment was written so bad. No, there's nothing wrong with the way the 14th Amendment was written. It's the interpretation. If you read the language, that's not what it says.
All right, so we're going to talk more about incorporation here in a little bit, but that's the overview. From the original intent standpoint, incorporation does not exist. And if it were, The crafters of the 14th Amendment, they did a lot of debate. If they wanted to incorporate it, they would have darn well said it, and they did not. They did not. But I wanted to bring this one up because this is going to be, I think this is going to get appealed to the Supreme Court, and maybe we can actually get an incorporation case heard by the Supreme Court, but I am not optimistic because after the Bruin gun case, even Clarence Thomas is open to incorporation, but they're wrong. So, Ron, take me off screen. We don't need to talk about this case much more, so I wanted to lay out the incorporation case. Bottom line, I state that the Bill of Rights does not appeal to the states. Their decision, basically based on the First Amendment, applying to what a state can do within its own borders, they should have no jurisdiction over it whatsoever.
Did I hear you correctly? Clarence Thomas is
the Bruin case. He used the McDonald case as evidence of incorporation as well.
Wow, that's just
it's Doug and I talked about it at the time. We were both a little rattled by the Bruin case, which we're going to talk about here in a second.
And it was at that time that I decided I liked Alito just a little bit more. Alito is closer to an originalist than Tom. I love Clarence Thomas, don't get me wrong, but he's a textualist, and there is a difference between a textualist and originalist. And Alito usually acts like an originalist. Every once in a while, he starts sounding like a textualist. Textualist basically is someone who goes by what the text says. Text says by a basic reading. And the problem with textualism is then a lot of the modern day definitions get put in there when it comes to defining what the text says. An originalist is going to go back to what were the words meant originally. And that Alito is closer to that than any of them.
All right, Ron, pull up the screen if you don't mind again, what I'm sharing.
Here, how about
for those of you wondering about the shirt, cockroaches in Washington, right? We complain about the cockroaches in Washington, but we breed them locally. Don't breed them. For those of you who are fans of what I do, you've heard that one a few times.
Well, if you're wondering about my shirt, it's the Michigan National Championship shirt. All right. So here's our scorecard. We need to give a grade on this Partain versus Florida. I don't think we need to talk much more about it because Doug nailed what was wrong with it right away. Doug, you want to go first and give a grade?
Big fat F.
Ron, what say you?
I am F as well.
And I am going to step further and say F minus. If state of Florida doesn't want that nonsense being taught in its public schools, it is none of the federal court's damn business.
I agree.
All right, our next case we're going to jump into is Wolford versus Lopez.
Okay. Do you have a
No, I got nothing to show there. Hang on, where did it go? Okay, it's down at the bottom here.
You're jumping one. I thought you were going to go through birthright next.
No, I am not going to go birthright next. I'm going to go Wolford Lopez. I'm skipping around because this is so. This case in Hawaii, the background is Hawaii passed the law in 2023, just under 1 year after the Supreme Court made the Bruin decision. In Bruin, the court invalidated a New York handgun licensing law. Notice what I said there. The court invalidated a state law that required state residents who wanted to carry a handgun in public to show that they had a special need to defend themselves. The court also made clear that the Second Amendment protects a broad right to carry a handgun outside the home for self-defense. In his opinion for the majority in Bruin, Justice Clarence Thomas emphasized that courts should uphold gun restrictions only if they are consistent with the nation's historical tradition of firearm regulation. What's wrong with that?
Well, the firearm regulation is expressly given to the states, not the federal government.
It's certainly not forbidden to the states, and it's not supposed to be a federal negative of state law. That was discussed in the Philadelphia Convention dozens of times, and the founding fathers were very adamant that there would be no federal negative of state law.
And when you're looking for historical evidence, all you have to do is look to the fact that as we moved westward, there were towns that would not allow guns in their towns, and you would have to hand them over to the sheriff on the way in because they were not allowed, and the towns were allowed to do that. There was no lawsuits against them. Now, you may or may not like it. It may be good or bad from a local perspective, but that's up to the local
right.
jurisdiction. And so there's also historical precedent that so Thomas was actually wrong on that, because I just brought up historical precedent. Now the thing is about the Hawaii case that's fascinating, though, is it is a bad law.
Yes.
And they should not have made the law. It's just not the federal government's job to tell them you can't. The people need to take care of that.
If your state makes a bad gun law, work to change it in your state, or get the hell out of that state.
Well, and the other thing about it, though, is the reason why it's a bad law, one of the main reasons, it's about private property. Who is the government, no matter what government it is, to dictate to you on your private property if a gun should be allowed, not allowed, or whatever? But it's public access. Doesn't matter. It's his private property.
All right. So before this Hawaii law that had to do with the private properties Doug mentions, 3 Maui residents with concealed carry permits, as well as local gun rights groups, went to the federal court to challenge the law. Big mistake right there. Federal court should have no jurisdiction.
Right.
A federal appeals court upholds the ban, finding that there was likely a national tradition of prohibiting the carrying of firearms on private property without the owner's oral or written consent. Supreme Court on Thursday struck down the Hawaii law that makes it a crime to bring guns on a private property that is open to the public unless they have the property owner's specific consent. By a 6-3 vote, the justices agreed with a group of Maui residents with concealed carry permits that the law violates the Second Amendment's guarantee of the right to bear arms. In his 24-page opinion for the court, Justice Alito wrote that the law hobbles what the Second Amendment protects: the right of Americans to carry arms for self-defense as they go about their daily lives. Justice Ketanji Brown Jackson, who dissented, countered that the law fairly applies a first principle of property law, the right to exclude, and does no harm to the Second Amendment. There's a lot to unpack there, guys. First of all, it's one of the very few times I agree with Justice KBJ.
I was about to say, am I on Mars now, or what?
I think the place they're looking for is Never Land.
Something like that.
But I don't agree with her logic, Ron. I agree with her finding because she thinks it doesn't address the Second Amendment. Well, yes and no, but not for the reason she thinks.
Yeah, she's right for the wrong reason.
Right.
Thank you.
Right.
Well put.
Very well said.
So let's unpack this one. What is wrong? I mean, how many things are wrong with this decision? They upheld private property rights, which is good, but they're applying the Second Amendment.
It's still a state issue.
Thank you, Doug. You got anything else? I mean, I see the hamster wheel running around.
Yeah, but at the same time, I think I've said what I need to say, but without getting into a big long soliloquy. And we've had this discussion. Now, the only time that I have perceived in my mind that the federal government could get involved in any gun law ever, and we've had this discussion, I've really been thinking about it, is when it comes to making sure that you have constitutional carry throughout the country. Why? Because of the Fourth Amendment reciprocity. So it wouldn't be because of guns, it'd be because of reciprocity, is my point. But when it comes to, if it's just about gun law, then we've got a problem. Now, when you have property rights, well, that's something you could see the federal government having authority over, to a point. And even that is shaky. But my point is, in the long run, it really was none of the federal court's business. They should have stuck with the state court's decision and left it there. It should not have been appealed to the federal court system. The problem is we have a society that sees everything as a hierarchy. You've got municipal, county, state, federal district, federal circuit, Supreme Court. It's not a ladder. They are two separate ladders, and it depends on who has what jurisdiction.
That's equal.
Let me. So, I'm working on. You guys know what I'm working on, and I'm coming across stuff, and it's like in order for the in order for the Fabians to get their way, they had to do institutional capture. And I could think of two institutions that they captured in order to essentially put this, or actually three. Number one would be the educational system. Number two would be the media. And number three would be the courts. And so by the education system, it has gradually, since the progressive era or just before, bred into the population the idea that the federal government is supreme over the states. Number two, you've got the media reinforcing that. And then number three is you've got the justices and the courts essentially making decisions that affirm that. And that is completely transformed and flipped 180 degrees the understanding of our method of government. And the most clear understanding that you can get in terms of how that has worked is watch how many people show up in each individual election. And what you see,
there's one more component there, Ron, to what you listed there. There's one more component, because you talk about the different institutional, captures. There's one more, because you have to convince the people not to believe their eyes and ears. So you also need to put in place ideological capture, where the people.
Well, I mean, that's right, and I guess,
and that you're dancing around it. You're essentially saying it, but the term is ideological capture.
I think that was the schools and or the educational system.
Well, it goes even beyond that. I mean, we've got a society, because what they'll do, and I think Plattner is a great example. What they'll do is they'll throw out there something so radical that now their left-wing policy or whatever it might be looks more normalized.
Right.
And also, getting back to the Fabians with the gradual incorporation and of these policies and these ideas, and then you feed it through the institutions. And what that does is it creates ideological capture. It creates where the people accept it, it's normalized, and even if their eyes and ears see something that's completely nuts, they're so captured by it that they just kind of don't notice it or don't care.
Yeah, this takes us all the way. Yeah, what are you talking about?
I don't think I don't think it's a thing that they don't care. I think it's a thing that they don't understand. And
absolutely, though, it has gotten to the point where they don't care. I'm a Democrat and I vote Democrat, and I don't care if they're a bunch of communists. We got to get rid of the racist Republicans. That's ideological capture.
The whole idea behind incorporation was to get us to accept that we have a national government that is, basically Big Daddy over everyone, and we all have to obey its orders. And that is not federalism. That is not what the Constitution was ratified on. That is not what that is not what the Federalist Papers said. It's what the Anti-Federalists feared. But what the Federalist Papers said is what was actually ratified. The Constitution never gets ratified if there's incorporation. We just got done with the first case, unanimously agreeing that, big shocker, that the First Amendment does not apply to the states. Now I'm saying the Second Amendment doesn't apply to the states. So my question for you guys, Ron, you want to put the scoreboard back up? Should the Supreme Court even have heard this case in the first place? And if so, did they get it right?
I never heard it, and they got it wrong.
They should have never heard it, and they got it wrong.
Ron, give it a grade.
So I am going to be, where am I here? Which one is it?
Wolford versus Lopez. I'm the one typing it. Don't worry about it.
Oh, you know what? Because I have it on. I have one on mine as well. But
yeah, use my screen share, please. Yeah. Okay. Now we want to give it a grade. Ron?
F.
Okay. Thank you. Douglas?
D- only because they were willing to consider property rights.
Yeah, it's a solid D for me, but I really want to give it an F. Because I do think they did strike down a bad gun law. So if their heart's in the right place, their brains are in the wrong one. Fair enough.
Fair.
I don't see it on the screen, so I don't know if you
got it. I don't. Yeah, I'm gonna have to do this and then add. There we go.
Yeah.
Okay.
Yeah, should show mine. I'm keeping it up there. All right. Next case we're doing is going. I need to do. Yeah. Okay.
Let's do birthright citizenship because I know everybody wants to hear that.
That's next. Trump versus Barbera. We can do that, which is the birthright citizen case. So let me read the background real quick. It's just so you know, Doug and I have got a video out there previewing this, and we thought they were going to get it right. We were wrong. We listened to the oral arguments.
Yeah, and I just wrote a very, very long article about it, and then a summary about it at douglasvgibbs.com.
Okay, so the question here is, are children born to non-citizens, quote unquote, subject to jurisdiction thereof? The court ruled 6-3 against Trump's executive order. In a decision by Chief Justice John Roberts, the justices agreed with the challengers, as well as all of the lower courts around the country that have considered the issue. The Trump's order cannot be reconciled with the 14th Amendment. Here we go with the 14th again. To the Constitution, which confers citizenship on born in the United States and, more importantly, subject to the jurisdiction thereof. Let me read the opinions, and then we're going to go off on it. Writing for the majority, Roberts emphasized that the children born of parents unlawfully or temporarily present in the United States satisfy both elements of the citizenship clause. Under the Constitution, he concluded, they are citizens at birth. Where the hell does the Constitution say that? Sorry. In a dissenting opinion, Justice Alito called the ruling both one of the most important decisions in the history of the court and a serious mistake. He goes on to say, careful analysis of the text of the 14th Amendment and the process that led to its adoption, Alito argued, shows that it does not degrade the concept of U.S. citizenship in this way. Instead, he contended the 14th Amendment confers citizenship on only those children who at birth owe allegiance solely to this country. I'm just going to sit back and listen to these guys rant because
early on the problem was that they would leave out subject to the jurisdiction thereof and just leave in, but the subject to jurisdiction thereof became such a counter argument to birthright citizenship, they decided they had to come up with a definition, and their definition is basic legal jurisdiction, which is inside the country's boundaries and subject to the laws. That's legal jurisdiction. What the founding fathers meant was political jurisdiction, and there is a difference between the two. Legal jurisdiction, political jurisdiction. Political jurisdiction is allegiance, and it's even more than that. If you have full jurisdiction, then you do things that visitors or temporary people can't do, like serve on a jury, things like that. I may have limited legal jurisdiction, let's say when I'm visiting France, because I have to, stop at the stoplight and all that, but I don't have full jurisdiction. So I can't be pulling out my gun saying, hey, I have the right to keep and bear arms. Not in their country, I don't. And so, that and that's the problem here. Now, we can get into all of the nuances that we have repeated over and over and over until it's been, pounded into a dead horse in the middle of the field. But, we can get into the birth tourism and Trumbull and Howard's testimony before Congress, all of that. But what it all comes down to is the definition of jurisdiction. And the problem is what they meant was legal jurisdiction. That's confirmed by other cases, dicta in other Supreme Court cases, by the Civil Rights Act of 1866, and by just basic history and the founding fathers' worries about, say, like the Tories. And this is very dangerous because it not only devalues citizenship, but it opens up the door for an invasion that the left's already, when I say the left, I don't mean local left, I mean in the world, has already been conducting against us. And it's now going to be increased tenfold, if not more. And this is dangerous. This will be the end of the country if we don't get this changed quick.
Listen, I don't disagree with anything you just said. I'm just saying I went and I was going back because I wanted to be right on this issue, and I believe everything that you guys are saying is absolutely correct. The only and I'm not saying that I agree with what I'm about to say. I'm just saying this is what I found, that when these particular issues were raised in the debates of the 14th Amendment in Congress, or whenever they were getting ready to pass it, back during Reconstruction. And apparently that was why it was raised that they wanted to put all persons or only certain persons, but they chose the all persons language because several of the people in Congress actually foresaw this potentially being, if you put all persons, the problem that we're talking about. And apparently there was a Supreme Court decision. What was it? Long Kim Ark or something like that.
Wong Kim Ark.
Wong Kim Ark, right? That's the decision that's really kind of being used here.
But the problem is they're saying the decision saying that something that doesn't say.
I don't disagree with you.
They sit there and they say, well, it says if you're born in America, so. Well, that's what he sued. His lawsuit was, I was born in America, so therefore I'm a citizen. But what they found was, because you got to remember, and subject jurisdiction thereof, all persons doesn't matter if the and is not satisfied. The and subject jurisdiction thereof has to be satisfied. That being there is the reason why when someone holds up their hand and gives an oath for naturalization, they are required to renounce any other allegiance. It's because of and subject to jurisdiction thereof. In Wong Kim Ark, the question was, okay, he's born in America soil, but is the and subject to the jurisdiction thereof been satisfied? And they determined it was because his parents, who could not become citizens because they were Chinese, did the next best thing. They became permanent residents prior to his birth, therefore, and subject to the jurisdiction thereof was satisfied. But see, they leave that out. Or it's like when they were talking about English common law. And so in English common law, if you were born in the empire, you were a subject. But what they leave out is you didn't get full rights or inheritance rights unless your father was a subject also when you were born. Being born on British inside the British Empire was not enough for the rights just to be a subject.
Well, there's a difference.
They're leaving a lot of stuff out.
Let me say one thing. Where this here is probably the most evidentiary, hardcore, ironclad proof of what screwed up the country in terms of the 14th Amendment, because the original Constitution never really discussed citizenship because it was determined that citizenship was a state citizenship, and you never really
to the country was mentioned. That is not true.
Well,
now it is partly true. Yes, it was understood you were a citizen of your state, but you're also a citizen of the country.
But in order to be a citizen of the country, you had to be a citizen of the state. Yes, am I getting that right?
Not necessarily. No, they went together. So you didn't take one to do the other because they were already tied together.
Well, but what I mean
is the citizenship of the state was really a pre-Articles of Confederation idea. The idea of you being a citizen of your state remained only because the states were their individual entities.
But let
me dumb this down just a little bit for people like Chief Justice Roberts, who apparently apparently thinks there's something in the Constitution.
Well, yeah, because there's scant evidence. He said so in his opinion.
He goes, it's in the Constitution. Where? Show me where it says that. No, to dumb it down, there's a difference between a citizen and a subject. But we're talking about subject to the jurisdiction thereof. If I travel to Mexico and I do something illegal, I'm subject to their laws. But Mexico cannot draft me into their army because I'm not one of their citizens. That's subject to the jurisdiction thereof. That's
political jurisdiction. That's the difference between legal jurisdiction and political jurisdiction.
Yep, 100%. You want to go deeper? Or I think we've beaten this one up a lot over the years.
Well, I mean, we could beat this horse till it's freaking blue and purple and orange and bleeding all over the place, and I don't think all we're going to do is just get frustrated.
Congress.
This is a very passionate one for me, so the audience might think I'm
and me.
So what they ruled is that Trump's executive order cannot define what subject to jurisdiction thereof means, but can Congress? And the answer, I think, is yes.
Well,
will they? I'm not going there.
Well, the president could because there is a law, the Civil Rights Act of 1866. He was executing that law, and that law was not superseded by the 14th Amendment Citizenship Clause. It was made a companion. They are companions with each other. So the law is still in force.
But
and his job is to execute a law. He was executing that law because what it says in the Civil Rights Act of 1866 is if you're born in the United States, but you're a child of someone who has foreign subject to a foreign power is the language they use, then you're not a citizen. That's what it says. And the very same guys who wrote and proposed and sponsored the Civil Rights Act of 1866 are the guys who wrote the Citizenship Clause.
But what my question is are they using the 14th Amendment as the justification for their decision?
Yes.
I said, if they're using the 14th Amendment, then Congress can pass a law. But if it gets challenged in the court, it's going to have to go up against the 14th Amendment, and then the 14th Amendment.
Well, you got to remember Doug. Tell them what Article 5 of the 14th Amendment says.
You talk about amendments?
Yeah, Article 5 of the 14th Amendment. I've got it right here.
Oh, you're talking about 14th Amendment. I'm sorry. Go ahead.
The Congress shall have the power to enforce by appropriate legislation the provisions of this article.
Okay. All right.
So Congress can do it. The question is, will they?
Now, and there's one other thing, and nobody talks about this, and that's the exceptions clause. And the exceptions clause is in Article 3, Section 2. And what it does is when Congress takes exception to a judicial opinion, in other words, if the judicial system gets it wrong, or they disagree with it, or it's unconstitutional, Congress can pass law to override any judicial decision. That's the exceptions clause. It's at the tail end of the second paragraph of Article 3, Section 2. And this is something that nobody talks about because the politicians don't want anybody to know about it. They don't want people to know that Congress can override the judicial branch. You know, they talk about checks and balances. They want the judges and the Congress to micromanage the president. And in reality, the real check is Congress on the judges. The judges have no checkability against anybody. They can write opinion, but they can't dictate to the executive branch or Congress what they can or can't do. But Congress can make null and void a judicial decision or a judicial opinion with law.
Well, and it's civilizational suicide if they don't, because I mean we know about the birthplace tourism. Interestingly, Texas, some state legislator just put something out today that Texas is making it illegal for these medical facilities to conduct birthright citizenship, and he's actually also proposing that state of Texas stops issuing birth certificates to non-citizens.
Now, the chat brings up something, and it's based on a misnomer. So Donnie Vision says, we didn't have this argument when No Name was running for POTUS, and I believe they're referring to Obama. That was natural born citizen. Natural born citizen and birthright citizenship are two different things.
No name
is John McCain.
They have made them the same thing.
I think
they are two different things. I'm answering
Doug, listen up. No Name is not Obama. No Name is John McCain.
But I think the gentleman in the chat is probably referring to Obama.
Okay.
And even if he's referring to McCain, once again, the question is, well, whether or not he was natural born citizen. Once again, natural born citizen, birthright citizenship have been merged into the same topic by today's political madness, but they are two different, separate ideas.
Yeah. So, no one's doubting that Kamala Harris or Barack Obama, well, maybe a little bit of doubt, but let's say Marco Rubio or Ted Cruz, they are U.S. citizens at this point in time.
Well, no, Kamala isn't.
Well, I guess she never was naturalized. That's why I hesitate on that. But they are not natural born.
Yeah. She was born here. 2 students on student visas. That doesn't confirm. It does, according to these jerks in this case.
Natural born is the president. Office of the presidency is the only office that requires natural born, and it is different. Ron, let's go to the scoreboard. Let's get a vote on this. I'll go first this time. That's going to be an F.
You don't have enough room for all the minuses I want to put in there, so just put F minus. Trust me, I'd put about 20 minuses if I could.
I'll put a G for me because that's worse than F.
How about incomplete? They're not doing. SCOTUS is not doing too well so far today, are they? All right. Let's see, we're doing pretty good on time. Let's just keep going in order for now. We'll do a quick one. Little versus Heckox, and this is about transgender athletes in sports. It's also there was a similar case called West Virginia versus BPJ. It's about West Virginia enacts a law called Save Women's Sports in 2021. Before the law takes effect, Pepper Jackson, who wanted to compete on her school's girls cross country and track teams. This is a guy trying to be a girl, sued to block its enforcement. Pepper Jackson had begun socially transitioning in 3rd grade and has taken puberty delaying medication and hormone therapy. She's now in high school. Saying it's she. He is now in high school. I'm not going to play their language games. The court upheld state laws banning transgender girls, women, dudes trying to be chicks, from participating on female sports teams at publicly funded schools. The vote was 6-3. It reversed and remanded the lower court decision in the opinion written by Brett Kavanaugh on June 30th. Remember, Kavanaugh was the coach for his daughter's basketball team. You remember those pictures? So this is personal to Kavanaugh. Justice Thomas and Gorsuch wrote concurring opinions. Justice Sotomayor wrote an opinion concurring in the judgment in part and dissenting in part, joined by Justices Kagan and Jackson. Jackson also wrote an opinion concurring in the judgment in part and dissenting in part. So here's what they said. Kavanaugh says, consistent with Title IX and the Equal Protection Clause, we hold that the states may maintain women's and girls' sports for biological females. They may determine eligibility for women's and girls' sports based on biological sex. The Constitution and Title IX do not require an overhaul of women's and girls' sports throughout America. That was Kavanaugh with majority. Sotomayor's dissent, which she reads from the bench out loud and very angrily, showing how strongly she feels about this. She says, in the end, to the court, the facts do not matter, even though the consequences are serious. How dare some dude trying to be a chick not be able to beat up girls just trying to compete in sports? How dare they? Sorry, that wasn't her. That was me. All right, going back to her quote. The ban is absolute, so BPJ cannot practice on a girls' teams, even if he would not take anyone's spot in an eventual competition, even if everyone who tries out for the team makes it, and even if having the chance to participate could aid immensely in treating BPJ's gender dysphoria. Sports, of course, are often zero-sum. The law need not and should not be. Side note, this ruling will protect similar laws in 25 states that have been enacted in recent years. What say you, gentlemen?
All right. So the interesting thing about this is it's right, wrong, and in between. From a moral standpoint, they got it right. From a constitutional standpoint, it's interesting. It's a little complicated. The law being used is Title IX. Title IX is technically unconstitutional because it's none of the federal government's business. However, the job of the president and the job of the courts is to execute federal law and apply federal law, and they do not have, either one of them, the job to interpret whether or not it's constitutional. So whether or not that Title IX is constitutional is not their concern.
So it
is that it is federal law.
This goes back, Doug. This goes back to our question: should Supreme Court even be looking at this in the first place?
Right. They can rule in the sense of if someone is breaking the law, and that's what it's about. The law, Title IX, is being broken. It's not so their job is that they would take the case because it is federal law. Federal law falls in their jurisdiction. It's an unconstitutional federal law, but that's not for them to decide. It is, in fact, a federal law. So it does fall in their jurisdiction. And based on the law is being broken. Therefore, they can rule that it is being broken. So they got all of that right. What's wrong is the fact that the law itself is technically unconstitutional, but they don't have the authority to interpret it. It is the law. If it needs to not be the law anymore, then us, through our representatives, need to do that. and give it back to the states.
It's black and white. It's either A or B. There's no interpretation needed. Right?
Right, but the fact is the law exists, and the job of the courts and the executive branch is to execute and apply federal law.
Right. And
it is not their place to say, but it's not constitutional, it's black and white. That's not their position. Their place is it's law.
So Doug, in chat, Donnie Vision asks, why is Title IX unconstitutional? If we go back to the original intent.
Yeah, go back to the enumeration doctrine. There's no enumerated authority giving to the federal government authority over athletics, education, gender, sex, none of that.
Those are all supposed to be left to the individual states as basically experimental labs to find out what works and what doesn't.
Yeah. It belongs to each state as per the 10th Amendment. But once again, that is for Congress. If they pass an unconstitutional law, the president's only chance to use his interpretation power is to veto it. Once it is law, it's law. His job is to execute the law. And the court's job is to hear cases regarding federal law. And if they believe the federal law has been broken, then they can rule against who broke the law. And that's what happened here. So from the basic legal parameters, everything is exactly as it should have been. The only problem is the law itself is unconstitutional, but that's not, once again, that's not for the courts or the president to decide. That's for Congress to decide and repeal it, or for us to decide, start throwing people out so it can be repealed by Congress.
Ron, you got anything to weigh in on it? Or you want to give it a grade?
This particular one is a little outside my true scope of understanding, and I don't want to. I mean, I'm just kind of listening to you guys, and I'm like, I'm in the deep end right now, and I can't really touch the bottom. So,
retroactively, and I don't want to go deep into this, but just to address it, if we were, in hindsight, and I've talked to you guys about this before.
On the surface, I agree with the decision to you know what. If you're gonna, I think whether you're a male or a female should be judged on your biological equipment. Enough said.
Yeah, chicks with dicks should not be able to compete with legitimate biological females. It's not fair. It is not fair athletically.
And
it's downright dangerous.
I said earlier that I agreed with that I agree with Ketanji Brown, and so I don't want to be lumped in there. About what's a woman. So.
All right, let's get the scorecard. Let's give the grades on this.
All right, B+. I'm going to go first. B+. The only reason why it's not an A is because technically the law is unconstitutional, but everything else they did exactly right.
I've got Ron, pull the scoreboard up.
Oh, my bad. My apologies. I just say an A just because it's, I'm glad they finally just, they judged in terms of biological sex.
Okay, I'm going to actually be a B- because I'm more upset about the fact that I don't like their entire rationale. They didn't state it as clearly as I would like. And I agree with Doug that they shouldn't have been ruling out in the first place. But
and you can put an asterisk by my A because this, again, like I said, I feel like it's a little outside my scope. I'm not really familiar with Title IX and all that other stuff, but whatever.
All right, well, they finally got something right.
Yeah. And I guess that maybe that's my my simpleton way of looking at this particular one is that at least they got that part right. So
the next one we're going to do is Trump versus Slaughter. The Federal Trade Commission, FTC, was created more than a century ago. It has 5 commissioners. The rule says no more than 3 of whom may come from any one political party. Very interesting rule because we're not supposed to have parties engraved into law. Each commissioner is appointed by the president and confirmed by the Senate to serve a 7-year term. During his first term in office, Trump nominated Rebecca Slaughter to fill one of the Democratic seats on the FTC. Then fake President Joe Biden renominated her in 2023 to serve a second term. Last year, the White House notified Slaughter in a letter that she had been removed from the Federal Trade Commission effective immediately. The letter did not cite any of the legal grounds that would allow Trump to fire her. Instead, Trump told Slaughter that allowing her to remain on the FTC would be inconsistent with my administration's policies. That's a quote. Slaughter goes to court in D.C. to challenge U.S. District Judge Lauren Ali Khan. I think that's another one of the foreign-born judges. Ordered the Trump administration to reinstate her. A judge telling the executive branch what to do. Okay. And a divided panel of U.S. Court of Appeals for the District of Columbia rejected the government's request to pause that ruling while it appealed. They wrote, only the Supreme Court could overturn its decision in a century-old case called Humphrey's Executor, which in their view was controlling in Slaughter's case. By a vote of 6-3, the justices struck down a federal law in the Supreme Court just 2 weeks ago that bars the president from firing members of the FTC except in cases of inefficiency, neglect of duty, or malfeasance in office. That law, a majority of the justices ruled, violates the constitutional separation of powers between the three branches of government. And in reaching that decision, the court overruled its 91-year-old decision in Humphrey's Executor, which had upheld the law at the center of the dispute. Writing for the majority, Roberts contended that the president must have the assistance of officers he can trust. Although it is up to the Senate to decide whether to confirm those with whom the president would prefer to work, neither Congress nor the courts may saddle him with those with whom he cannot work. Subordinates who exercise the president's power are subject to removal by him. Then and only then can they remain accountable to the president and the president to the people. It's actually it's a decision by Roberts that I very much agree with his wording. Justice Sotomayor penned a 49-page dissent that was joined by Kagan and KBJ, of course. And getting all histrionic as always, Sotomayor says, today, the court discards the democratic regime created by the Constitution. That's a direct quote. In favor of one that distorts the structure of government to fit the majority's theory of unitary total executive control. The result, she concluded, is a president who emerges with far greater power than ever before. Gentlemen, any thoughts?
Yeah, but I've been jumping up first. I was going to let you guys talk first on this one because I do have some comments that may be a little different.
Ron, you want to go first?
I
can talk real quick. I can lead you in it because
I had to go do something real quick, and I didn't hear everything that you'd said. So
Roberts opined that the president, even with Senate confirmation, that you can't saddle the president with people in his executive, in his executive branch that he cannot work with. He has that option. He is the executive, and this leads into the concept of the unitary executive, which is a more powerful president than probably the founders intended, but it's that's something that's been around for more than a century. And as the executive branch continues to gain some powers never intended for it, but at the end of the day, the ability to run the executive branch, you can't say you're stuck with these people that are your subordinates that are insubordinate, and that's what Roberts said in a nutshell. I'm okay with the opinion. I think Roberts actually wrote it well. That'd be like I come in as I get hired as a CEO of a publicly traded company, but I can't fire. I got a CFO and a chief operating operator that are undermining me at every turn, and I can't get rid of them.
Well,
how can I do my job?
And to your point, I think it's like, yeah. I mean, is Trump the executive of the executive branch? Is he the chief executive of the executive branch? And is that not does that not fall under the executive branch? And does he not have authority over that? It's like, so basically what you're saying is the president is the chief executive, but the courts are the one who can decide whether or not they can be fired.
It's exactly right. And that Humphrey's Executor case from 91 years ago, basically it's a separation of powers issue that allowed the courts to tell the president that he actually cannot run his own department. And that's what they're overturning a 91-year-old bad precedent. And I'm all in favor of this. Doug? You're awfully quiet.
So separation of powers, first of all. And now let's use only the language of the Constitution to talk about this one, and it'll become clear. So in Article 1, Section 8, the final clause, it says that Congress shall have the power to make all laws which shall be necessary and proper for carrying into execution the foregoing powers and all other powers vested by this Constitution in the government of the United States or in any department or officer thereof. That basically says it is up to Congress to make law to create the mechanisms for the president to execute the law. So that is their job. Create and dismantle any agency, department. But once it's created, their authority over it is gone. Because at the beginning of Article 2, it says the executive power shall be vested in a president of the United States of America. The executive power is the power to execute the law. He is the grand poobah. He owns the power to execute the law. So any vehicle, tool, vessel, whatever given to him to execute those laws fall under his authority. Now, some of those mechanisms are not always under his authority. For example, militias are not always under his authority, but once they are, he becomes a commander-in-chief to execute the law or anything else. But agencies, departments are made specifically for the purpose of executing the law. He has the executive power. Once created, none of Congress's business, none of the judicial branch's business. It's his business. It's his branch. His agency or his department. He uses them as he feels is necessary because he's in the real world applications. Since when did desk jockeys know how to do anything that's going on in the real world? And so and I believe there's another case with independent agencies on your list. Is there, Warhamster?
Yeah, that's part of the conversation, and we're going to do the next the Trump versus Cook.
Because the independent agencies argument falls under this exact same thing. Congress will tell you, well, we created this agency to be independent. No, if it's executing law, it falls under the executive branch. There is no independent agencies. Congress cannot make agencies for themselves because they have no execution authority. Their authority is only to create law, modify law, strike down or repeal law. But the execution of law only belongs to the president. So if any entity is created to execute the law, he is head of it, period. Now, if they don't like the way he's doing it, then he'll be gone in the next cycle.
I'm glad I knew Doug was going to bring up the independent agencies because that's going to segue into our next one. So keep that thought in mind because there is no such thing as an independent agency under the Constitution.
No, there is not.
That would be called a rogue agency like the CIA, although it's not supposed to be. It just acts like one. Let's give this one a letter grade, boys. Ron, go first and pull it up on screen.
I'm gonna give it a B.
Put it up on screen, please. I'll go next and give this one a solid A. They got this right.
I'm going to go A minus only because some of the language I would have liked them to have used, they didn't. They didn't get into, for example, the necessary and proper clause as much as I would have liked, but they did get it right.
I just think a lot of these agencies and whatnot. I mean, it's just bureaucratic bloat that never really should be there in the first place. But
no, of course not. But this is how you get a ruling class of an authoritarian government that pretends to work for the people, even though it works for itself.
Well aware, and that's why I gave it a B because it shouldn't be there in the first place. It just shouldn't be there in the first place. You know, where did I hear this the other day? It was in a debate with it was like Stephen A. Smith had a couple of guys debating, and this one guy Anton Daniels, I think he says, government is not there to do everything for you. The government is supposed to be there to clear the way so that you can be successful.
All right, Short Bus. I know you're typing probably your answer, Warhamster, but let me go ahead and respond to him real quick. In the chat room, he asked, I'm confused. EPA, CIA, Federal Reserve, ATF can only be abolished by the president. No, that's not what's being said. What was being said is agencies and departments, which is on your list except for the Federal Reserve, can be created by Congress and dismantled by Congress, but the operations, hiring, firing, how the operations are handled, what they do, all of that belongs to the president. The Federal Reserve is not a department or agency. It's an outside non-government entity. And while the president does have the authority to appoint the personnel to it and remove them, because that's his authority, the Federal Reserve itself can only be dismantled or gotten rid of by law. It would require a repeal of the Federal Reserve Act.
Which brings us to our next court case,
Right.
which is Trump versus Cook. And this one's got a lot of attention. So since taking office in 2025, Trump's attempted to assert control over several multi-member independent agencies whose officials could also be removed only for cause. Not necessarily, not anymore, not after the previous reading. However, the Federal Reserve is different than the FTC because it is a quasi-independent part of the government, and therefore it's extra constitutional and unconstitutional.
Yeah, the only thing federal about it is the fact that the word federal is in its name.
It is not federal. There are no reserves. It's not a bank, and the system is messed up. But so this woman Cook is a Federal Reserve officer.
Mm-hmm.
In August, Trump posted screenshots of on social media of a letter to Cook in which he fired her. Trump alleged that Cook, who was nominated to serve on the Fed by then fake President Joe Biden in 2023, had committed mortgage fraud back in 2021. Cook denied the allegations, calling them flimsy, unproven, and conveniently timed following the president's criticism of the Federal Reserve Board's policy decisions. Several media outlets have reported that financial documents may undermine Trump's contentions. We're not going to litigate that today. Cook went to federal court. U.S. District Gia Cobb issued an order requiring the Fed to allow Cook to remain in office while litigation continued. Cobb concluded that Cook was, quote, substantially likely to show that Trump had violated federal law when he fired her because the for cause requirement does not allow the president to remove a board member for her conduct before she took office. The firing also violated Cook's constitutional right to fair treatment, Cobb added, because she did not have notice and an opportunity to contest her firing before it occurred. Didn't know that was required. Myself, not in the private sector, it's not. Writing for the majority, Chief Justice Roberts contended that if the Trump administration were correct, it would in effect transform the Federal Reserve's for-cause protection into at-will employment, an interpretive leap out of step with a statute Congress enacted and a nation's tradition of central banking protected from political interference. Leave that hanging there for a second. Sotomayor, Elena Kagan, Brett Kavanaugh, Ketanji Brown Jackson joined in the Roberts decision. In his dissenting opinion, Justice Clarence Thomas called the ruling incorrect. And he says, although the court expresses concern that the president removed a board member for the first time in the Federal Reserve's 111-year history, he wrote, it expresses no such concern that it today upholds an injunction against the president's removal of an executive officer for the first time in the Constitution's 237-year history. So they've just ruled that President Trump can fire anyone in the executive branch. And they're now saying, but that does not include the Federal Reserve because for some reason it's considered protected from political interference. It's a tough one.
Board members appointed by the executive serve at his pleasure.
Amen.
End of conversation.
Is the Federal Reserve part of the executive branch?
Doesn't matter. He has the authority to appoint those commissioners, and therefore it is his authority to put in or remove. He doesn't have the authority to dictate the operations of the entity, but he does have the authority to appoint and remove those particular individuals that law has given him the authority to appoint.
He can appoint with the advice and consent of the Senate. Mm-hmm. Are you saying that it also means he can remove without the advice and consent of the Senate?
That's a good question. I believe in this case, yes.
I don't agree. Nor do I. First of all, let's start. I don't think the Federal Reserve should be allowed to exist.
Well, of
I
course,
agree.
it shouldn't exist in the first place.
Yeah.
No, I absolutely.
It's it's an extra constitutional, outside the constitutional entity that runs by its own rules. Trump's trying to bring it back into the umbrella of the Federal Reserve, and they're actually making an exception for the Federal Reserve, and they're trying to put that into ironclad law. So I'm not crazy about this decision.
Can the president fire the Department of Justice chief?
No.
Should he be able to?
What?
No.
What?
You believe it still requires a Senate's authority?
Oh, I'm sorry. Did you say the Attorney General?
Attorney General, yeah.
Yeah. Okay. You said okay. That's different.
Chief of Department of Justice, Attorney General.
Well, you said chief, and I'm thinking Chief Justice. So you got me confused.
I'm sorry.
Okay, so
Yeah.
I think that
So to me, the appointment of these officials to the Federal Reserve Board are exactly the same. They serve,
they should,
at his pleasure.
The pleasure of the president.
While it takes the Senate to approve putting them in, to remove them, that's up to him.
Right, I agree. I agree with that. I don't.
Yeah.
But the Senate isn't necessarily the Senate isn't agreeing with the president. He's just saying, okay, they're just making sure that this person is either qualified or gets through the.
They're approving the
confirmation. It's like a stamp of approval. It's not necessarily. And not necessarily a stamp of approval. It's just like, okay, well, we will clear
it is a stamp of approval to go in, but to go out, that's up to him.
I agree.
Only if the Federal Reserve
and the Federal Reserve positions are no different. The only difference is the Federal Reserve is not an agency or department, but his authority to appoint them is the same as with any other appointment.
Yeah, it's a murky argument, and I get both sides of it. Again, the Federal Reserve shouldn't exist in the first place. The fact that it exists as a quasi-executive branch, although it operates independently, the independent Federal Reserve is fundamental, to be outside of political constraints at all. So if it's going to be outside, no, you cannot have if you're going to have a Federal Reserve, a central bank, and it's supposed to be independent, it cannot be subject to political pressures of a president. And President Trump's been trying to put pressure on the Federal Reserve to lower rates because he wants to lower inflation and help out the midterms and all that kind of stuff. He wants to help his own agenda, and they've been resisting because apparently they're these mature stewards of the economy. We know they're anything but on paper that's what they're supposed to be. So you can't put them
because they're anti his agenda.
But they're not independent if he's appointing. They claim to be independent, but they're not totally independent because he can't appoint. They want to be totally independent, then he can't appoint. And if that happened, then the people would freak out and it would never be allowed. And they knew that. That's why they allowed for the appointments.
Well, but the point is that the Senate isn't involved in the process of appointing the guy anyway, other than just saying,
confirmation. I get that, but my point is, it's coming down to independency. Either it's independent or it's not.
Well, the Supreme Court has now ruled that it is not part of the executive branch, except for when it isn't.
The entity isn't a part of the executive branch, but he has that authority to appoint. And if he has the authority to appoint, then he has the authority to remove.
Well,
if they want to say they're independent, then let's remove the president's attachment to it and let it be what it really is, an entity that is really just a bunch of bankers dicking around with our economy.
All right, so Doug, going with your logic, the federal does the executive appoint judges to all the district courts? Yes, he does.
Yes.
Can he remove them?
They need to be impeached.
Bingo. So he does not have the power. That breaks through your logic right there.
No, not at all.
Because
we're comparing apples and oranges.
Because that's a different branch.
Now they're in the judicial branch. They're in another branch of government. He no longer has the authority. The only authority to remove comes from the legislative branch.
But the Federal Reserve is not a branch.
Well, the Federal Reserve is a quasi.
So it doesn't belong to another branch.
Well,
the only connection to any branch it has is him, and those are his people. So he
Supreme Court has just ruled that it is an independent branch.
All right. So how about this? Okay. So I have a advisor that sits in with another company. Do I have the authority to remove them at will? Yes, but they're at this other company. Doesn't matter. It doesn't. Even though they advise in that company, that for me as one of my advisors, that doesn't mean that I can't yank them and put someone else in there.
Yeah, but you didn't hire them for the company in the first place. You just hired them to represent the company. It's a little bit different. It's a tough.
Is not the federal government's board members basically that advisors? They do some voting, but they're really advisors. In the end, the bankers do what the bankers do.
All right, let's go to the scorecard, Ron.
I just want to make sure of one thing. You're saying that the Supreme Court essentially has now ruled that the Federal Reserve is its own individual branch.
Yeah,
what they're saying is that that it is so independent that the president cannot yank who he put in there,
which in effect makes it outside the executive branch.
But then why is he appointing if it's outside the executive branch?
Well, it's not part of the government. It's not a government agency. It isn't.
Then he shouldn't be appointing them.
Bingo. But then had they done that,
but because he is appointing them, he should be able to pull back who he appointed. Just like if I sent an advisor somewhere, I could bring him back.
But if that were the case, Doug, the Federal Reserve never would have been able to fly through.
Exactly. I said that. That's why I said earlier. Nobody would have accepted it. That's why they allow it.
On Christmas Eve, the thing was passed. The Federal Reserve Act was passed in 1913.
Yeah, it's all about banking systems. It's all about bankers. It's not about anything else anyway.
Ron, give it a grade.
Again, I'll give it a G. F minus. I mean, to say that it's an independent branch essentially it's not the fourth branch of government.
That's not what they're saying. It's an independent entity, but nonetheless, F.
F for you?
Yeah, you can put F for you. No, yeah, F.
Wait a minute. I'm actually more of a D plus. And
because you think, I go ahead, explain it. Yeah.
Well, according to the current interpretation, the Federal Reserve is outside. In fact, I'm actually into a C on this. Because of the current interpretation of the law, they actually got it right. Because the Federal Reserve is considered outside the executive branch. They've ruled correctly based on that assumption. That assumption is incorrect. The conversation of whether the Federal Reserve should even exist in the first place needs to come up. And they've just thrown a really, really bright divisive line between what is the executive branch and what isn't. And based on that, I'm really happy they ruled the way they did, because now we can have that conversation, say where exactly does the Federal Reserve fit in this triangle of separation of power?
And it does definitely encourage discussion about whether it even should exist anymore.
Yeah, if they're their own entity, a fourth branch of government, where's the check and balance on it? Outside of appointments, apparently there is none.
I was about to say that could be a silver lining in this whole thing.
That's where there's C. That's why I'm giving it a C, Ron.
You know what? I'm gonna reconsider mine, and I'm gonna go along with you on that, because I think that the fact that they did this opens it up for the discussion to have that's a potential win.
Thank you. I agree, because you can't. What they just described cannot exist under the Constitution. Cannot.
That's right.
From a legal end, I can't make a judgment based on what it could accomplish. So my grades.
I understand. I understand that, but if you are essentially the way they have ruled, and Brady's kind of brought me over on this one, is that, you know what? That they've opened the discussion. That I can't give it anything above a C, because, again, to your point, it is theoretical. But the theory here now is that we can actually have the discussion, whereas before we couldn't.
Okay. Are we going to try to stop at 4:30 your time, Ron, or can we go a little bit over?
I can go a little bit over, but not much.
Yeah, excuse me, I'm okay.
I want to skip. I want to get to two more important ones. We'll skip over two, and I want to get straight to Watson versus RNC. And this is the mail-in ballots by election day. Doug and I did a show on this recently, and I know Ron's talked about it before. This is the Mississippi case of whether you can send in mail-in ballots 5 days afterwards. Let me just give you the quick summary of it. Bear with me. Mississippi passed a law at the center of the dispute in 2020 for COVID response to allow mail-in ballots. Idiots. Writing from the majority, Amy Coney Barrett concluded that the election day statutes require the electorate's choice to be made on election day. That occurs so long as election day is the deadline for individuals to vote, as it is in Mississippi. But the election day statutes do not set a deadline for ballot receipt. So they do not prevent Mississippi from counting ballots postmarked before election day, yet received afterward. Roberts, Sotomayor, Kagan, and Ketanji Brown Jackson joined Barrett's opinion for the court. In the dissenting opinion, Alito argued that from this nation's founding until the last few decades of the 20th century, a period that spans the enactment of all 3 election day statutes, having an election on a particular day meant completing ballot collection on that day. Thomas Gorsuch joined Alito's opinion, while Kavanaugh joined most of the opinion. Like I said, Doug and I just did a recent show on this entire case. We went through the entire oral arguments, and we thought they were going to get this correct. I do not think they did, and I'm furious about it. You have Christmas Day, you got Valentine's Day, you have Election Day. It doesn't mean, if I give my wife her Valentine's Day chocolates on February 26th, I'm in a boatload of trouble. It's February 14th is Valentine's Day. Otherwise, I'm sleeping on the couch. It should be the same way with Election Day, and that's what a lot of the questioning was. The most interesting line of questioning was Gorsuch during the oral arguments. And he was making the argument of how do you, what indicates you've made your choice? Because if I put it in the mail, let's say I use a private carrier like FedEx on Election Day, and it hasn't been delivered yet, it's like 3 more days, I can still recall that. What if a scandal comes out the day after Election Day and I can undo my choice? You've now, by definition, extended Election Day because of the ability to recall. And that's what's at stake here. Do we have an Election Day or do we not have an Election Day? And the best argument to say is, okay, if it's not received by Election Day, it doesn't count. If you think mail-in ballot has to be part of your electoral system, and we're not going to go into that because that'd take hours, you should extend the mail-in balloting before Election Day, not after. They got this wrong.
I think if you're going to put mail-in ballots, I think the mail-in ballots should have a postal stamp of like 5 days before Election Day. If it shows up after Election Day and they're still counting, okay, so be it. Then we can count it. But then that way it's like that way it's you give a little bit of a buffer. But to say that
reasonable.
What's that?
That's reasonable, Ron. That's reasonable, but it won't impact.
This is a politically influenced situation that didn't used to exist. We were talking earlier about how Clarence Thomas, we talked about with Second Amendment issues, how we want to go back to the historical tendencies in the past and how was it throughout history. Election Day has been Election Day. Absentee ballots and mail-in ballots are not the same. So first of all,
I have
no problem with absentee ballots if it's requested for a good reason, but mail-in ballots, that's ridiculous. But even so, and I speak from experience here, the history is Election Day was Election Day. How do I know this? Because when in 1984, when I voted for Ronald Reagan, I was stationed at Naval Air Station in Mississippi, but I was a California resident still. For the most, even though I'm in the military, that was my home base. And so I applied for an absentee ballot. And on the envelope, it says to make sure you mail this early enough so that it is received in time for Election Day.
Exactly.
And this is California back in 84. This is the way it's been always understood. So if we want to use history, if we want to get into Clarence Thomas's comment about Second Amendment and really the court's position that historical, the way it has been historically, consistency throughout history is a part of the ruling, then they ruled wrong because they violated the very historical consistency throughout the history of this country.
So to me, the biggest issue with all these, lax election, you're creating so many opportunities for mischief.
Absolutely.
We gotten up to, and you want to create fewer opportunities for someone to get up to no good. The history, there's been cheating in elections since there have been elections. The United States in the 1850s and 60s was probably the dirtiest elections in history.
Gangs of New York.
Without a doubt. Radical Republicans, all that stuff. I mean, Lincoln never won a legitimate election, for the love of God. But you don't want to create more opportunities for mischief. You want to create less. And what they've done is they've created so many opportunities that you can't just pigeonhole, oh, you must have cheated me this way, because there's so many different ways of doing it. And you lose trust in the election, which we don't have. I mean, obviously, we saw it happen in California. They'd be counting for 30 days. The joke going around right now is, the U.S. soccer just lost to Belgium, and someone put out a tweet, "Not so fast, Belgium. We're still counting. Still counting the goals for another 29 days in Los Angeles. We'll let you know."
I tell you what, I saw a thing where Trump came out and said that it was his decision, or he's the one who essentially made it so that Balogun could play. And I was talking to my friend yesterday, and I'm like, man, if that's the case, I absolutely am 1,000%. I'm against that, and Trump should not be out there pushing that he's the one that did that.
Keep politics out of sports, please.
Absolutely.
All right, let's. We've gone really deep into this conversation in the past. You can go back on my channel not too long ago and see a conversation Doug and I had on this. But they had the vote. Let's get the scorecard up there. How'd they do on this one, guys? Oh, hey, let me ask another question first. Big issue with this is, should the federal government be determining how states run elections?
Nope.
Yes, Article 1, Section 4 allows Congress to pass laws regarding federal elections. The rest of the elections belong to the states.
Okay. Okay. I can see that. The federal government should only have a say on federal elections, not state elections.
Define a federal election. Define a federal
Article
election.
1, Section 4 gives the states the authority to handle it, but it also gives Congress the authority to write law to alter their regulations regarding federal elections if they think there's, it's not right. And this is and here's something that's interesting about that being in there. During the convention, there was a lot of arguments about not allowing the federal legislature to negative state laws, but this one they allowed. So because of all the argument against that, there's a darn good reason why this one remained in place.
Okay, can we define what is and what is not a federal election?
Federal election would be any election where any person who would be elected to federal office would be on the ballot.
Okay, let me.
Well, that's not completely accurate, because when it comes to the electors for president, that is left completely up to the state legislatures, and there's no allowance for Congress to be involved. If you go to Article 1, Section 4, it's elections for House of Representatives and U.S. Senate.
And you can make the argument. I know what Article 1, Section 4 says, and so I'm arguing against that. But the way, if I'm supposed to have local representation in the House of Representatives, my district is a local election. It's not federal. I'm sending someone to go serve in a federal office, but it's a local election. The U.S. senators were supposed to be elected in the state legislature. That's not a federal election. That's a state election. So technically, there is no such thing as a federal election.
Because they had such experience, even in the early days of America, though, with manipulation of elections, they felt the necessity to put that in there.
Understood. So based on that, should Supreme Court have even taken up this case, and did they get it right? Let's give it a grade, guys. Ron?
I give it a C+.
Let's put it up on screen, please. I'll go next, Doug. This is an F for me. It's an absolute fail to protect our elections. It is. This is one of those times.
Oh,
you're talking about civilizational suicide.
Mm-hmm. You know what? Let me take it back, because I was going by some of the things that we were just talking about, and they were more theoretical, not necessarily based on the decision.
Yeah.
What the decision about what they did? No, I am in absolute opposition. That's an F.
Yeah.
Anytime
I conflated. My apologies.
No worries. Anytime you have to explain rape, some kind of a federal statute with 3 amendments going on and stuff like that, to do something that is clearly makes the elections less secure, you are not fulfilling your oath to the Constitution to uphold the law. It is crystal clear that this ruling makes it far easier to have less faith in our elections, which is going to be the demise of the entire republic. And that needs to be their fundamental principle. If the Constitution got something wrong, this is their chance to stand up and say, guess what? The wording in the Constitution, if we're going to believe in judicial review and that's their job and that's the oath they took, they failed big time. They have created something that could actually destroy Western civilization. And they had an opportunity to put a Band-Aid on that, and they failed to do so. Absolute failure to me.
The actual question here when it comes to a ruling is the federal law that's in question. Did they follow the federal law? Did they properly interpret the federal law? And they failed immensely. They decided that election day doesn't mean election day, it means election season. And so it's an F minus.
And I'm furious about that. We'll just give that another 0.0. All right, we're going to have to go to Louisiana versus Collide. This is the one about race-based redistricting. I'm not going to go into all the details on it because we're getting short on time. But
it's all about the gerrymandering, yeah.
Yeah, this is, can you have race-based districts? In a 36-page opinion, Alito explained the Constitution almost never permits the federal government or state to discriminate on the basis of race. Yay. And race-based redistricting is reverse discrimination. They ruled against it. We've got a bunch of the gerrymandering is going to go back the right direction. Because of this, the Republicans have a very good chance of maintaining the House. This decision was delayed by months because KBJ, Ketanji Brown Jackson, was delaying her dissent for month after month after month. And this was problematic because we were coming up on election season, primary
That's why
season.
she was doing that. That's exactly the reason.
In sum, he says, because the Voting Rights Act did not require Louisiana to create an additional majority-minority district, no compelling interest justified the state's use of race in creating SB 8. The map is unconstitutional gerrymander, and its use would violate the plaintiff's constitutional rights. Thomas agreed brilliantly, and I just want to read Kagan's dissent. In a somber tone, Kagan read a summary of her 48-page dissent from the bench, a signal of her strong disagreement with majority's ruling. The Voting Rights Act, she wrote, is, or now more accurately was, one of the most consequential, efficacious, and amply justified exercises of federal legislative power in our nation's history. Love the language because it's all wrong. It was born of the literal blood of Union soldiers and civil rights marchers. It ushered in awe-inspiring change, bringing this nation closer to fulfilling the ideals of democracy and racial equality. And only Congress, Kagan argued, can say it is no longer needed, not the members of this court.
The way to get rid of racism is not to employ racism from the other direction.
I don't think we need to talk about this one very much because they got it right.
Solid A.
Yeah, agreed. A.
Can we go up on screen?
Coming. Even a broken clock is right twice a day.
Yeah, they got this one right. They just got it a little bit slow, but I'm still giving them an A+.
Ron, did you notice that usually I'm a little more harsh on these than Brady is? Usually. And every once in a while we'll flip, but usually I have a harsher grade. I always thought that was funny.
Yeah.
That's happened the last few times.
It depends on the case. It flips sometimes.
Sometimes it'll flip. Yeah. Well, it flipped a couple times here, but usually I'm more harsh.
The thing is that you're an originalist because you look at the Constitution and
he's a rodent. I get it.
Yes.
I don't know that anybody's more of an originalist than I am.
Well, I don't mean it. I'm not insinuating that you're not an originalist. I'm just saying that I think Doug has more. Doug is more well versed in the originalist aspect of it than you are. Is my point.
Yeah, I don't know. Warhamster though has been
he's gaining ground.
Yeah,
he's gaining ground.
He's on an upward trend for sure.
100%. I will concede that. And my saying that is not to impugn him in any way, shape, matter, or form. I'm just saying you've got a lot more history on this than he does.
Sure. But absolutely.
And
a little more experience in the sense of time.
Right.
Well, if Doug and I were in the Philadelphia Convention together, I'd be sitting all over there in the corner with all the anti-federalists saying, "Don't you dare pass this damn thing." And Doug's going to be in the reasonable guy in the middle saying, "We can pass it if we execute it properly." I would have been in the George Mason side, and I probably would not have signed the damn thing just because I recognize that people like Alexander Hamilton actually exist. But
I would have been right there with Madison, because I know that if we didn't, we wind up with the Articles of Confederation and everything collapses.
Well, the funny thing is that if you look at the anti-federalist positions and everything that they said, essentially that's what's come true. It just took like 200 years for it, or about 100.
They were right about human nature,
right?
Not about the Constitution, but the Constitution is in the wrong direction because of human nature, not because of the document.
We've got 2 more cases, but we're up against the hour. One is about the geofence warrants and the 4th Amendment, which they got right, I believe. And then the other one's about the conversion therapy. I don't think we have time to get into them since we're going pretty long. But we had 8 cases today. And the combined grade point average was about a 1.3, which is an average of a D-.
Yeah.
So they did not.
And if you had if you never had a Trump first term, they would be getting an F- at this point, I'm sure.
Yeah, this combined total of 4.
Well, if you wouldn't have had a Trump term, you would have had people like Merrick Garland on the court.
Mm-hmm. Exactly.
Oh yeah, and by the way, Mitch McConnell, who soon will be, I don't think he's not alive for the living as well. But we do have to thank Mitch McConnell and his senatorial gymnastics for keeping Merrick Garland off the Supreme Court, because that would have been a disaster. So as much as you might hate Amy Coney Barrett or Kavanaugh and some of their votes occasionally, they're far better than Merrick Garland would have been, because that guy's a dyed-in-the-wool communist.
I have to say that you are I agree with 100%. And like I said, a broken clock is right twice a day.
Yeah, the turtle did at least one great thing in his life and saved us from Merrick Garland. Quick question Collinwood asks, I know you guys don't want 3,000 congressmen, but how much gerrymandering could be done if every rep represented no more than 50,000 people? As obviously a lot of people here know, the original Bill of Rights, there were a whole bunch of them submitted. 12 made it to Congress. 1 has never, ever been ratified of those 12. And that was the one limiting us to, I believe it was 30,000 constituents per House representative. That would give us, almost 11,000 people in Congress. I've proposed some ideas about that, expanded electoral college for Congress type idea, where we vote for our local electors, they vote for an elector on top of them, and those people elect the Congress critters to keep us at a reasonable number. You do not want 11,000 Congress critters, although that would be fun to watch K Street lobbyists try to pay that many bribes. It'd be a lot harder.
Are you suggesting adding a second layer of bureaucracy under that House of Representatives?
The argument is that if they represent less people, they'll listen to you more. And my response is always, really? Look at city councils. They gerrymander and they're worse.
I think I would make it smaller than that, but in terms of electors. But it's a good way to get money out of politics, something like that. We certainly do not want 11,000 Congress critters. In fact, I think that's about 11,000 too many at this point in time.
Well, I think that I think the federal government is well, I'm learning all kinds of bad things about the federal government. So anyway, I don't think the people that are representing the country now in the federal government are I don't think they really have any understanding of how they got to the position that they're in, and and I don't think the people the people that are actually voting completely understand it either. I mean, I didn't even understand it until recently, I didn't understand it to the degree that I do until recently, and it's far worse than I ever thought it was. So
yeah. Well, everyone goes, is it fixable or is it so broken? Is it beyond repair? No, it's never beyond repair. But
well, I think JFK said it best. Our problems are man-made, therefore they can be solved by man.
unfortunately, humankind is a very flawed species. Driven
And
by
we don't have the persistence once we start heading in the right direction to keep doing it, because we don't properly hand the baton off to the next generation like we should.
well, that's because the people that actually are in control make sure we don't, and they keep us distracted with this stupid right versus left nonsense, and instead of thinking about right versus wrong, and that's a big problem.
Right versus left, black versus white, whatever mechanism can be used as a tool of division is utilized to keep us fighting laterally as opposed to looking up and down.
Mm-hmm.
All right,
Ron, I love it. Ron, I love it when you borrow my quotes from 5 years ago and say it, articulate it perfectly.
That's my.
I tried to make it sound like it was his idea. So on my way out the door here, folks, my latest book went live today at Amazon. The Constitutional Presidency of Donald J. Trump. Every accusation of him being unconstitutional, I address in this 26-chapter book. It has an index. It has, full constitutional. It has Constitution in it too, for that matter. The bibliography. It's well researched, and it's available for $20 on Amazon. So just look up The Constitutional Presidency of Donald J. Trump by Douglas V. Gibbs. I will have a link on douglasvgibbs.com shortly. There is a link also at my other website, navigation2liberty.com, navigation, the number 2, liberty.com.
I'll be ordering it. I need to. I've actually, there's 3 of Doug's books that I have not read yet, so I need to get on that and 2 others. But
well, I'm very happy with this one. This is the best book I've written since Repeal Democracy.
If you don't say so yourself.
If not better. I'm very happy with it.
The one I'm working on actually is a 2-parter, volume 1 and volume 2, and it's the creation of the military-industrial complex, and I'm taking it all the way back to. I'm tracing it all the way back to the Opium Wars.
Did you catch the episode I did with Colonel Tanner Watkins on Friday when we were going through the Pilgrim Society? And I said, I watched the Colonel went off and talked about how, all these original Pilgrims in 1903 in American was a combination of the corporations, represented by Rockefeller and people like that, Carnegie, the diplomats of the time, a bunch of military officers and stuff like that. And she explained, all these people. I go, Colonel, you realize you just explained the birth of the American military-industrial complex right there, 1903. That's when it happened. But Ron's going to take you back further, because war profiteering is a game almost as old as war itself. And Ron's talked to me about the book. I think it'll be excellent. I look forward to it. Gentlemen,
I just put the link for the book in the chat if you're watching live, or if you're watching this video later.
I'm not seeing it. You put it in the right place, Doug? Because I don't see it.
Yeah, it's in there in not our chat, their chat.
I'm looking at their chat. I don't see it.
I don't see it either.
Anyways, audience, I hope you enjoyed this. This was like a rapid fire speed round Supreme Court scorecard. That's the way it had to go. We went to a lot of really deep constitutional topics in a quick amount of time. These gentlemen had really good questions, thoughts, and I thought it was pretty profound. We'll be doing this periodically because it's important.
Yeah, Doug, put the link in the comments, not the chat, because the live chat really isn't available to people after the fact. So, and if you put it in there, I'll pin it.
This has always been one of my favorite episodes of the year because it touches on so many topics. We get to go so many different directions with it, and again, it's speed round. We can't get as deep. I mean, every single one of these cases could do it. We could do a 90-minute show on.
Absolutely.
Yeah. This is the lowest combined scorecard the Supreme Court's had in the 3 years Doug and I have been doing this show. And Ron, we'll make sure that you're the third part of the panel from now on. You did great today. Ask good questions. Yeah. I instinctively, I knew you'd be good when I asked you to join us on this one.
Well, and for fortuitous that it just happened to be this way. But next week, Next week we're going to get back into the history of the colonies and whatnot. And I guess, are we going to get back and are we still talking about the Carolinas? Wait, we haven't finished.
We were wrapping up the Carolinas at the last show, so we're going to get into some other stuff.
I didn't think but I recall we were talking about stuff. We got into talking about things where we didn't.
Yeah, I had just a little bit left of the Carolinas. It was pretty much wrapping it up.
Very well.
And it was nice to see that you're wearing Angels red today.
Well, you know what? I just thought I would. Red is Republican allegedly. So that's really where I was really going with that.
It's also communist. So I mean, who knows?
Well, Ron, did you know the red was not red became the Republican color?
I was just about to say, look, go back.
It used to be a true blue conservative.
True blue conservative and blue dog Democrat.
Right.
They changed the colors in about 1984, I believe. If you go look at the presidential map of the 1984 election, Reagan was blue. And well, who was it? Who was it? Mondale? Was it Mondale in 84?
Yeah.
So Mondale. Yeah. Mondale barely won his own state, and that was the only state that he won.
Yeah, it was Mondale.
He barely won Minnesota, and that was the only state that he won.
And I think he got Washington D.C.
Does that count?
I'm just saying.
Well, of course he's going to get Washington, D.C. Come on. I mean, does water wet? Shit.
D.C. shouldn't have an electoral vote. Not even supposed to.
No, they shouldn't, but they do.
Exactly. They have about as much of a right to vote as Puerto Rico.
Yeah, so you can see it in the
Washington, D.C. needs to be a square again. That'll save Virginia from the commies. That changes the entire republic. Make it happen.
Hey, I agree with that.
I just saw a headline. I didn't read the damn article because it was disgusting. That said that basically was saying there's a ranking that Virginia was the most patriotic state in the country. And
my God.
Yeah, New Hampshire came in number 10. That was one of the worst lists I've ever seen. I should have saved it just to share because it was so bad. California was way down there, which is legitimate. Yeah, unless you
close to the top should have been like Wyoming and Arkansas. I think those are the two most.
I think Montana was number 2. Yeah,
that makes sense.
Well, less so
yeah,
now.
But of all of the states way up there in the big sky country, they're the ones that have put Democrats in office a handful of times.
Yeah, my buddies in Montana are bitching and moaning about all the Californians moving up there buying all the. Yeah,
Montana's the most liberal big sky state.
It's getting bad.
Well, it's they're just following the Colorado model.
Well, then you look at the Dakotas. We get people like in Wyoming. We get people like Liz Cheney, John Thune. You can't trust a red state anymore. I mean, that's the problem with having, our politicians in D.C. do not represent their local constituents. They represent national political parties.
Well,
repeal the 17th.
And the problem also goes with pure democracy. The senators are. In order to pull it off, need the vote of whatever big city is in their state. And so they have to be more moderate in order to pull it off. And so what you get are moderate Republicans rather than truly constitutionally minded or rural minded Republicans. If we get rid of the 17th Amendment, get rid of Reynolds v. Sims, you will get a true constitutionally minded Republican, rural minded Republican.
All right, I got to share one last thing with you guys because this politics are hot right now. As most of you know, I live in New Hampshire, right across the bridge from Maine. I had to drive up to Maine yesterday for my heart cardio stress test. And by the way, the doctor said I've got the cardio system of a 30-year-old, which made me feel very good because I'm actually older than 30, if you didn't guess. But it was really good. Yeah. So anyways, but as I go over the bridge to get into New Hampshire, to get into Maine, you're in a town called Kittery. And it's right on the Maine border, and everywhere I looked are Graham Plattner signs in the yard. And then this news broke yesterday, so I'm gonna go back over there. He's got until
see if they're still there.
He's got until the 13th to withdraw from the Maine, and then the Maine Democrat Party has until the 27th to name a replacement. But so if he hasn't resigned by I think it's next Monday, he's in there and he's going to lose. But I'm going to drive back over the bridge after the Plattner news to see what yard signs come up next. And by the way, you will not see a single yard sign for Susan Collins anywhere in southern Maine. I haven't seen one. But she'll probably going to win, and she's one of the worst Republican senators in history.
Western Maine and northern Western Maine, that's where, it's not so crazy. As for your heart and probably your lungs, I've been told by my doctors I have the heart and lungs of a young man too. Unfortunately, I have the joints of an 80-year-old man. So, you give and take,
30 years of contact sports. I never break a bone, and I fracture my hip in the freaking carpet in the bedroom.
Yeah.
Oh,
that's got to go on my tombstone.
Gentlemen, it is. I'm very happy to hear that both of your hearts are in the 30 range. That's awesome. So,
yeah. Well, I used to be a long distance runner, and he's
clearly you're not watching. Clearly, you're not watching any baseball. So.
Well, it's too depressing.
If you were watching baseball, your heart's.
Yeah, no, it's too depressing. I haven't been watching baseball. I started baseball at the beginning of the season. I quit months ago. I think it was last month.
The only sport I care about is watching Norway win the Soccer World Cup, because that guy Haaland is the ultimate Viking warrior, and he is inevitable. I am the biggest Norway fan in history. That's who I would want to be in my alter ego if I actually played football. That guy.
I love the fan base. Whoa. Yeah. Whoa, I love that. That's cool.
Half of America is rooting for the Vikings, and
I think so. Yeah.
I hope they can do it.
Now that the U.S. is not there anymore, thanks to Belgium.
I tell you what, I was disappointed at the U.S. Exit, but I mean I was expecting a little bit more. But I think the whole thing with Balogun and the red card, I think all it did was really motivate Belgium, and they came out and they
were so
they
good.
Put them on defense. They put them on defense the first 30 seconds, and the U.S. lacked the composure to even. I mean, just absolutely. And
they whooped their ass. They whooped our ass.
That was so uncompetitive and so heartless. I'm just furious.
I almost wish that the whole Balogun thing would have just been left alone, and then let the Americans do what they could have done with what.
Play as the underdog. You have more heart. And then you watch the game before that. Mexico lost to a superior England team, and they went down fighting to the last freaking second. So cheers to Mexico. You guys played their balls off. I mean, they left it on the field.
In defense of Mexico, they're playing at 7,000 feet, and the English are playing at the English are never accustomed to playing at 7,000 feet. And the fact that Mexico stayed in it was.
Let me debunk this, because I played rugby up in Reno and Lake Tahoe. What was the name of the Reno team I played? There's a famous rugby tournament called the Wild West Rugby Fest, and the people that live up in Reno and Tahoe think they have some kind of elevation advantage, and you do. Because when it comes to playing sports at elevation, it takes about 2 weeks to acclimate. And then you go down to sea level, and about 5 days after you're down to sea level, your superior lung capacity is back to normal. So when you go down to travel to the flatlands, it doesn't carry over. And I played up there, and rugby is an incredibly hard cardiovascular sport. And playing, 4 90-minute matches in a 2-day tournament is pretty brutal. And I've done that.
Shelly the Kiwi, and there we have it. Put 3 men together, and eventually sports are going to get talked about.
Well, I will say this about soccer: I don't have the patience to watch soccer. So what I do is I wait until afterwards, and I put on the special 12-play miniature version, because I don't have the patience to watch it all.
But yeah, Shelly said herself, she's a rugby guy.
She was a rugby girl.
She's from New Zealand. Of course, she's a rugby
guy. I'm aware of Kiwi.
I was actually hoping, beyond anything, that the Australian government, if they weren't so woke, were going to open up their borders to a lot of the South Africans that are getting persecuted, white South African farmers.
Yeah.
Because if you put the South African with the Wallabies, they actually would probably even be maybe more talented than the All Blacks, which is the New Zealand's national team.
Right.
That would have been fun. But the Springboks and a Wallaby combination would be, I think, unbeatable. Anyway, that's enough for sports for one night.
Yeah, I agree. All right, gentlemen, I need to skedaddle because I just got stuff I got to get done. So, a pleasure having you both here on the channel to discuss this. I think we did.
Pleasure to be here.
I think we did a pretty good job. I was, all things considered. So,
that's a tough format to go that rapid fire, and you guys did great.
Yeah. All right, gentlemen, have a great night, everybody. We will see you next time.
Cheers.